Hi, it is Jacques, your friendly debt counselor again. Welcome. If you receive the final letter of demand or a Section 129 notice, as it's commonly known as, you're probably a bit stressed or confused. Don't worry. I'll explain to you exactly what it means and what you need to do next to avoid any legal trouble. What is a Section 129 notice? A Section 129 notice is a formal letter from a credit provider in South Africa. It's basically a final warning before they take legal action. It means you're behind on your payments and they're giving you 10 working days to either settle the debt, make arrangements, or face further legal steps like court summons, judgment, or asset repossession. What you should do if you receive a Section 129 letter. First of all, don't ignore the letter. The worst thing you can do is just put it aside and hope it goes away. It won't. If you don't respond within the 10 days, the creditors will take legal action against you in the form of a court summons, a default judgment, or repossess your vehicle or house. Here's what you must do. Contact the credit provider and ask for a repayment plan. If they are not willing to do that, speak to someone who can legally help you to restructure your debt before it is too late. Debt counseling is a perfect way to avoid legal action and to protect you from losing your assets. But you have to act within 10 days. After that, you may lose important rights. How must a Section 129 notice be delivered to the consumer? According to the National Credit Act in South Africa, a Section 129 notice must be properly and probably delivered before any legal action can be taken against the consumer. Here's how it works. The method of delivery. The notice must be sent via registered mail to the address provided by the consumer in the credit agreement. This is the preferred method specified in the Act. Alternatively, the notice can also be delivered personally or through any method agreed to in the credit agreement, such as email or SMS. Proof of the delivery matters. What counts in court is that the credit provider can prove that the notice was sent to the correct address and the consumer had a reasonable opportunity to receive it. Important. The credit provider does not have to prove that the consumer actually read or opened the notice, only that it was sent correctly according to the law. Time frame. The consumer has 10 business days after the notice is delivered to respond, either by making payment, negotiating agreement, or seeking debt counseling, before legal action can be initiated. I help people who are under financial pressure to take back control of their finances before it is too late. If you've received a Section 129 notice, I can help you to understand what your next steps should be. I can help you negotiate with your creditors, and I can put legal protections in place to avoid any further action. To consult with me is always free. If you feel you need my help, please contact me on the contact details as listed below in the description. And remember, you are not alone in this. Help is available. And if you enjoy my content, please like and subscribe. Thank you for watching.